Hi, I'm Alex Kennedy. I'm a disputes associate here at Gannons, and today I'm going to talk about the unfair prejudice petition, which is an important weapon in the arsenal of any litigator in share disputes. So, what is unfair prejudice? The Companies Act has a mechanism by which the shareholders can petition the court for relief where the affairs of the company are being conducted in a manner which is prejudicial to their rights as shareholders. So, what rights does a shareholder have? Well, it depends on the company and how the particular individual became a shareholder. If I buy shares in Marks & Spencer's, my rights are fairly limited. I have the right to expect that the directors will act within their powers and will not breach their duties. But I do not have the right to be involved in the management of the company, to be consulted on strategy, or to see internal papers. However, if instead of holding shares in Marks & Spencer's, I hold shares in a company which I and my 3 friends founded together, I might have a right to be involved in the management of that company. And therefore, I would have the right to sit as a director, to see internal papers, to be consulted on key points of strategy, and to receive dividends in the same amount as my fellow directors. Usually a petitioner is seeking an order that their shares be purchased for fair value. This is the most common remedy sought in an unfair prejudice petition. Although the court does have an extremely wide discretion as to what they can order. It could be that the court orders that the company is conducted in a particular way, is restricted from taking certain actions or required to take certain other actions, or even that the majority sells their shares to the minority petitioner. Unfair prejudice litigation is very fact-specific, and therefore it is notoriously slow and expensive. However, because we know what the petitioner will usually ask for, that their shares are bought for fair value, we can short-circuit the process by offering to buy the shares of the petitioner at an early stage. So, for instance, we can agree that a valuer is appointed to determine the fair value for the shares and that they are then bought. At Gannons, we not only have a disputes team, but we also have specialist corporate and tax lawyers. So we're actually extremely well placed to help devise an innovative solution to buy back someone's shares in a cost-effective and affordable manner. And sometimes being able to buy shares in that way can help unlock the whole dispute. You give the petitioner what they want to be bought out, while also maintaining enough capital within the company and within the remaining directors and shareholders that they can continue to work in business. An alternative to an unfair prejudice petition is to seek an order for the just and equitable winding up of the company. However, the courts will not always accept that a winding up is required, and where a petitioner for winding up should really have brought an unfair prejudice petition, the courts may not be sympathetic to the winding up of the company, and they may not order the winding up of the company, the courts being reluctant to wind up an otherwise successful company. So I hope that was helpful. If you do have any questions, we'd be very happy to help. Gannons is a boutique firm that deals with all sorts of director and shareholder issues, and unfair prejudice petitions are chief among those. So we'd be very happy to help.